lot of people think that they don't need a real estate attorney or they don't need a title company to do their closings or to prepare their documents.
I have seen so many times where people use a non-lawyer or a non-real estate professional to do their documents. And what happens in the end is that the result that they wanted, say when they die or even, if they go to sell, is not what they anticipated.
Hi there, Erin Halstead with the Englewood Area Board of Realtors. I am your 2026 president, and today I have with me Lori Wellbaum from Wellbaum Law, and we're going to talk a little bit about real estate law, closings, trusts, and estate planning. So, Lori, what do you think is the biggest difference that people need to know between wills and trusts?
Well, first of all, thank you for having me today.
Thank you.
I would say the difference between wills and trusts is when you just have a will and you have an asset that's in just your name, say a piece of real estate. When you die, there is the probate process that you have to go through, or your family does. So with a trust, if you deed your property into your trust, there's no probate when you die.
So if somebody sets up a trust today and then they have another child down the road, you can always amend a trust to add more people if you want to leave your property to more people than you initially started out with?
Absolutely.
Okay.
We can always do amendments. I mean, I have clients that do 5, 6, 7 amendments. And so just as life goes on, you can change it at any time.
Okay. And everybody's situation is different. Everybody's life is different. So you don't, I'm sure, have just a blanket answer for anybody. The best way for you to give them advice is for them to come in and have a full consultation with you, and then you can help guide them on what's best for their situation?
Yes. Yep. We usually start with tell me about your family. If it's a couple, are you married? Do you have joint assets? Do you have separate assets? Do you have kids together? Do you have a blended family? And everything that they tell me will, frame how I give them their estate planning guidelines.
So blended family is a perfect example. We're seeing more and more of that. Do they have to specifically name stepchildren or spouses' children to have them included in a trust?
Absolutely, they do. If that is their ultimate goal, say to end up with all of the children as the beneficiaries, then they are going to both need to name them in their trusts or in their wills, however they do it. But if they don't, then only one side's family will receive the inheritance. And that really is not always what people want.
Okay. So are there any things that you see repetitively in your business that you think that the average person doesn't know or understand about real estate law and how things pass once they pass away?
Well, I think the biggest thing is to make sure that with real estate law that you're familiar with, say, how you take title, whether it be joint tenants with right of survivorship, whether you take it as husband and wife, or whether you take it as tenants in common, because all of those different methods are going to end up with different results when you die.
So is there a standard way that it's done if people don't ask? Because so many people here don't use a real estate attorney, they just use a title company.
I would say if it's a married couple, then almost always they're going to take it as husband and wife. That would be the default. If for some reason they did want half of the property to go towards each of their estates, then they would take it, as tenants in common. So that would be, I would say, for a married couple. Now, say two people, like if you and I bought a piece of property together, it would depend on what our ultimate goal is. If we want it to go to the other one when we die, then we would do joint tenants with right of survivorship. If more likely we would want it to go each to our own estates, then we would take it as tenants in common.
Okay. Yeah, well, that's good to know. A lot of people think that they don't need a real estate attorney or they don't need a title company to do their closings or to prepare their documents. I've seen a lot of things get kicked back because they don't have the proper number of witnesses. So can you talk a little bit about that and the need to have an expert on your side to do those things?
Absolutely. I mean, of course, I'm biased, but I really do feel it's so important to have a professional do your documents, whether it be estate planning documents or whether it be, a real estate deed. I have seen so many times where people use a non-lawyer or a non-real estate professional to do their documents. And what happens in the end is that the result that they wanted, say when they die or even, if they go to sell, is not what they anticipated. So I just tell people, spend a little bit extra money or go to a professional and make sure that it is done right. because the ramification for it not having it done right is really sometimes can be very expensive.
And you're not there at that point to even express what your wishes were. So it's sad to see that happen sometimes, that people had a specific idea of the way they thought things were going to be handled, and then the paperwork just wasn't done right, and it doesn't go to the way their wishes were.
Absolutely, absolutely. And kind of along that same note, we talk about, and a lot of the realtors that we deal with, is, specifically with our office at Wellbaum Law, have learned this, and that is there is a fine line between doing real estate and doing real estate law or law in general. And so we always tell them, leave the specific legal questions to the professionals. And so if you have a question, just call us. Don't try and give your own legal advice, whether it be about estate planning, probate, or even doing a will. I mean, absolutely have a professional do it for you, or give us a call.
Even in contracts, I've reached out to you before in contracts if we need to do an addendum or have specific wording. I am not qualified to write any kind of contract. So writing any kind of contract law is specifically forbidden, and you guys have been really wonderful with helping out with that.
Yes, yep, absolutely. If you want an addendum done and you just need some help with the wording just to make sure you've covered all of the bases, a lot of times we'll have our real estate professionals give us a call and say, can you just help me out with this wording a little bit, or check it over.
So when somebody passes away and their children inherit the property, say through a trust, and they're unsure what the next step is, what's the best advice? Is the first thing to set up a consultation with you and you can help them deal with their specifics of their situation?
Yes, absolutely. Have the family contact us, or the beneficiaries contact us, set up a consultation. We will go through their the trust documents or the will documents, and we will talk about their assets and what they have and how they're titled. And then we will kind of set up a plan of action, obviously, how long it's going to take, what the cost is going to be, if any, and where they need to go from there.
So if somebody doesn't have a property in a trust, but their will does specify who they want it to go to, what happens with the probate process? How long does that normally take? Is there any kind of specified normal timeline?
Yeah, and so just even to focus on what you just said, so if somebody has left something to their beneficiaries in a will and then they die, I would say, first of all, the most common misconception is that people will think they don't need probate.
Right.
And they're almost always very surprised that they do, okay? And they do. So from there, we do have to do the probate process, which is a court process. It takes about 6 months. And just so you know, it costs about 3% of the value. So it does get to be very expensive. Say for a $300,000 house, that's $9,000. So it gets to be very expensive. But we will walk them through that process if that's what happened. And like I said, it usually takes about 6 months. We'll see them several times to help them through the creditors period and everything else that's needed.
So during the time that a property would be going through probate, somebody still needs to maintain that property. Somebody still needs to pay all the bills. Somebody still needs to take care of the day-to-day details of managing a property. So that's why I think most people don't understand that the will, although it expresses their wishes and spells everything out, it doesn't immediately take care of that property. So I think most of the time you would recommend that people put a property in a trust.
Absolutely, yes, because especially like you said, during that time frame, even if they have their mortgage paid off, there's going to be insurance, there's going to be other expenses, homeowners fees, or whatever is needed. And so it really taxes. So it makes more sense to put it in a trust because the disposition of the property is significantly faster. And then especially if there are funds in the trust to help take care of it during that time, it's very helpful to the family to do that.
So to go through the probate process is months. If somebody has a property in a trust, what's the timeline to transfer on that?
Weeks.
Okay.
Weeks. Yep. Really the time frame, the biggest time frame is waiting for the death certificate to arrive. And that's usually about a 10-day process. And after that, it's just really a matter of us doing a deed for them.
So I've had some people tell me, well, I'm the successor trustee. I don't even need to do anything with the deed. Is that accurate?
If they're the successor trustee, and assuming they're also the beneficiary, they are going to want to still deed the property to themselves, through the trust. Because if they keep the property in, say, their parents' trust, and then they die, their family is going to be probating the asset as well. So, unless there's some specific provisions, they're going to want to go ahead and distribute that property out to themselves or them and their siblings or whatever it is.
So we as real estate professionals really need to still look at the trust, because like you just said, they may be the successor trustee, but they may not be the beneficiary.
Correct.
So that's a fine line that I don't know that I even know the difference of. So we still need to consult a real estate attorney to understand fully how to even read that trust, maybe.
So I know that with my trust, and I'm sure you've seen enough of them too, where the beneficiary provision is. However, when you get to a trust that another attorney has done or an out-of-state trust, sometimes it's very confusing. Sometimes they don't even list the name of the beneficiaries. They might just say my heirs or my children. So absolutely, it's very important to read it. And if you were not 100% certain on who the beneficiaries are, you definitely need to run it by an attorney.
Okay, so you brought up a really good point. You mentioned out-of-state trust. So if somebody sets up their trust in another state, is that valid in Florida?
We always give our famous lawyer answer of it depends.
Depends.
Okay, yep, it depends. Most likely, yes.
Okay.
Most likely, yes. There might be a few more hoops that we have to jump through, but most likely, yes, it is. Yeah.
Okay. So your recommendation is most people, their first step would just be consult an attorney.
Yes.
Okay.
Yes.
And then from there, you can split into two directions, and you could do one or both, the will or the trust, or you could do both.
Right.
Okay.
Exactly. Yep.
Everybody's situation's different.
It is. And really, that's the thing we do is we sit down in the beginning and we talk about it, and we talk about what their goals are, what their budget is, what they want to accomplish, and we take it from there.
Okay.
Yeah.
Yeah. Thank you for talking to us today. Do you have anything else you'd like to talk about?
No, I think that's generally the thing, is mainly like absolutely do not do your own documents. And if you do, at least run it by an attorney, because there's so many times that I see that creates problems in the end. Yeah.
Well, thank you.
Thank you.